Okay, this presentation is made in regards to Paul Anton for the Haggies. Let's begin. Okay, we first met Paul Anton back in December, at which time he had a few issues that he was dealing with, certainly with his lender, and he wanted us to perform an analysis for him. At that time, we determined he didn't have all the documents required to perform a proper audit, so we invoked a qualified written request to obtain the documents necessary to complete discovery. Then we ran some algorithms with him. This right here reflects Paul's income and expenses versus his loan amount, which is called the net present value test, or NPV. It was determined, and then again, this green section here reflects the Making Home Affordable program that Obama is touting as the way to save America's homes. In this example, given Paul's income at the time that we ran the algorithm, dropping his interest rate to 2% and extending the term to 40 years, we would still have to commute $275,000 to the back of the loan to make the target payment. So you can see easily why he didn't pass the NPV test. That being said, we started discussing more and more of the other things that are involved with his loan, inception, the refi, and the transfer of the note from hand to hand since he got involved in this property. We have a number of services and alternatives available to the consumer. First and foremost are our free services, no cost to the homeowner, the home affordable modification program that, again, I just showed you the algorithms that we already use and are also being utilized here in Orange County by the court system. It is a pilot program that is going to be outreaching statewide very, very shortly. It's important for the court to be able to show if the consumer can prove affordability in court when the banks are attempting to foreclose. So in Orange County, it is impossible for a lender to foreclose on a borrower if they appear in court and can prove affordability. They use exactly the same algorithm I just showed you. We're prescribing for Paul. In his case, since he's way past the simple loan modification, is a temporary restraining order. When signed off by a judge, we'll freeze the foreclosure until his case is heard and allow his case to be heard. We are also looking to perform a lender fraud detection analysis report that is much stronger than a typical audit you may get with another firm. What it does is it also allows us an opportunity to ask a number of questions, which we did already with Paul. We asked him about 162 questions about his loan experience, from inception to the refi, to the servicing, to title, to escrow, etc. And those items constitute consumer civil rights violations, which can deem a contract unenforceable and rescindable. We are then going to initiate a civil lawsuit against the lender, the servicer, and the beneficiary. We only recommend this in extreme situations such as Paul's. Typically, everything that we do is settled out of court. Again, we are very aware that the banks have very deep pockets to litigate. The consumer really just wants to get back to their life. What we're looking at for Paul also as a backdoor or as a plan B is a delinquent note investor purchase and restructure at market value, meaning we have a group of investors that purchases pools and trunks of non-performing notes such as Paul's. So very basically and very simply, once we initiate the lawsuit, the lender may or the beneficiary may actually put the note up for sale anyhow to avoid litigation. Well, if we offer to purchase it and we already have a litigation against the note, well, then we're very likely to have a successful purchase of the note. We'll be able to buy it at a discount because it's in default. We'll sell it back to Paul, 30-year fixed rate, dollar for dollar at actual market value. This transaction alone can save a homeowner hundreds of thousands of dollars off their existing principal simply by getting it commuted down to market value. So we buy the note at a discount, we sell it to them at market value. Now that dollar is truly worth $1. Keep them in it for a year, and then we sell the note back to the banking system with 29 more years of interest available on the loan at $1.75, if that makes any sense to you. So whether we have to compel it through the courts or we have to do a backdoor purchase of the note, we have more than one solution for Paul. The importance for Paul is that we act within the timeline. Okay, he's dealing with the foreclosure timeline, and he's passed the appropriate timelines for the state of California, meaning he's in dire need of help immediately. From the state of California, once you receive a notice of default, A minimum of 3 months and 19 days has to elapse before they can actually record a sale date. Well, we're well beyond that. So by virtue of the fact that the bank hasn't exercised its right to sell the home or to take it back through foreclosure, leads me to believe that they're aware that there's some foibles occurring in the inception of the loan and certainly during the refi that may need to be addressed. So I really think what they're waiting for Paul to do is walk away. I don't think they're willing to enforce the foreclosure at this point because there's so many mitigating factors in the case, certainly according to Paul and what we found in discovery. However, once they do invoke and complete the transaction of foreclosure, it's going to be a lot more expensive for Paul to retain this property or for us to try to get it back. And the odds are much, much worse for success. In terms of dealing with my firm, we don't deal with hours and paper. We deal with timelines. So his outstanding balance of $5,775 coupled with his deposit that he's already made will take care of all of this entire timeline here all the way through to the settlement conference hearing. Right now, we have accomplished discovery. We still need to do some research. Then we need to hurry up, draft, file, and serve the defendants. Then we get to open up negotiations. Paul is here without having done any of this back here. He needs a temporary restraining order now. Why? Because they can sell the home any day now. His retainer will cover from 12 weeks to 5 months, however long it takes to get our settlement hearing. We need to engage in mediation right now to not only stop the sale, but to negotiate a potential outcome for both Paul and the lender. Only when the settlement date approaches and arrives and no settlement has been made do we ever discuss another retainer, which will be a maintenance, if you will, to include additional mediation and actually go into jury trial. So that's the long and the short of what we're proposing for Paul. I hope that if you have any questions, you will forward them to me by replying to this email. I want to keep it short because I know the file size for this Windows Media type is kind of large, and if I'm sending it to Yahoo, they may not accept. So that being said, please see our website at www.4cpls.com, www.bankloanfraud.com, or www.freelegalloanmod.com. Thank you for the opportunity to be of assistance. I certainly hope this little presentation has been informative and the timelines are clear, and I certainly hope that together between yourselves and myself and Paul, we can make something positive happen in his particular situation. Thank you for your time and careful consideration.